So I saw a video yesterday where somebody said that he'd bought some goods from eBay that later turned out to be stolen, and the police told him that it didn't matter whether or not he knew that they were stolen when he bought them, he would still be guilty of handling stolen goods. And that's not quite true, and so I'm going to explain this situation so that everybody understands it. So handling stolen goods is actually a more serious offence than the theft itself, and it's taken to be because it will encourage further offences of theft. And so handling stolen goods attracts a prison sentence of up to 14 years. Now, in order to be guilty of handling stolen goods, two things must be in place. First of all, the goods must actually be stolen. You can't be handling goods that are not yet stolen. And secondly, a defendant must know or believe that those goods are stolen at the time that they acquire those goods. If they buy them honestly and they receive them honestly, not knowing or believing or having any reason to believe that they are stolen, then they cannot be guilty of this offence, contrary to what this video said the police officer said. However, the difficulty comes is if that person then retains those goods, then knowing that they are stolen or believing that they are stolen, let's say they are told that they are stolen, let's say that someone contacts them and says, "That's my property," and the person says, "I don't care, I'm going to keep it," then at that point, they are then appropriating them dishonestly because they knew or believed that they are stolen. And so if they then go on to retain those goods, they may well be guilty of theft or another offence under the Proceeds of Crime Act, which would probably be Section 329. Because Section 329 of the Proceeds of Crime Act 2002 provides that a person commits an offence if he acquires criminal property, uses criminal property, or has possession of criminal property. And so if in this position this person knows that these goods are stolen and then they have possession of criminal property and they decide to keep it, then they may well be guilty of an offence under Section 329 of the Proceeds of Crime Act as well. And this seems to be a hot topic of late because there was another video that I saw where somebody had consumed food at a drive-through that he knew wasn't his order, and a member of staff from the drive-through came out and said, "Can we have the food back?" He said, "No, I've eaten it." And then the server said, "Well, can you then pay for it? The manager would like you to pay for it because you've consumed the food knowing that it wasn't your order." The chap in the car said, "Yes, I've eaten it, but it's not my fault that you gave me the wrong order." Well, I'm here to say, well, yes, actually it is your fault that you've eaten the food that you knew wasn't your order, because you received the food knowing it wasn't your order, therefore you knew that it didn't belong to you, and then you went on to consume it. So you've treated it as though you were the owner of the food, even though you're not. On one analysis, it's still the property of the drive-through because they haven't yet delivered it to the customer. On another, it's the property of the customer because they've rightly paid for it, and so the contract has taken place and it's their food. But strictly speaking, because the drive-through gave it to the wrong person, the person whose food it really was should be able to get a reimbursement or replacement food from the drive-through, which of course the drive-through was trying to get from the chap that had eaten it. So on my analysis of this situation, the guy that ate the food that clearly didn't belong to him has stolen it. So I hope you found this interesting. Please like the video, subscribe, and I'll see you next time.